Hello, everyone, and welcome to Uncivil Law, and I hope you're having a great day. For today's stream, we're going to take a closer look at Karen Read's petition for habeas relief that she filed in federal court. Karen Read, as I'm sure many of you are well aware, is on trial for the murder of her boyfriend, John O'Keefe, the allegation being that she was mad at him, potentially because of romantic liaisons that were causing the relationship to somewhat sour. And she decided to murder him. And she apparently decided to do this by backing over him with her Lexus SUV, going backwards at 25 miles an hour in snow, ramming into him and causing him to pirouette, as we famously learned from Trooper Paul, landing in the snow to die there. And this was done intentionally with murder on her mind. We watched the first trial, and I found the evidence to be hilarious. I was truly amazed the state brought this case in this condition. There are so many evidentiary problems all over the place. It is truly ridiculous. I thought that this was probably a case where the judge should have more seriously considered entering a directed verdict after the stopping of the state's case. That's a pretty rare thing to do, but I thought it might be appropriate here because the standard after the state rests in presentation of their case is beyond a reasonable doubt. See, to bring the charge initially, all you need is probable cause. But the standard shifts once the state's case is over because, of course, the defense doesn't have to do anything. So at the end of the state's case, they've either proved it beyond a reasonable doubt or everyone gets to go home. And I thought, maybe not so much with beyond a reasonable doubt. I thought there were many problems, some of them involving leaf blowers and red Solo cups and flipped evidence tapes and 40 minutes missing from tapes and, physics. But what is physics anyway? A question that haunts both Trooper Paul and myself. But we're not here to talk about the evidentiary issues, although they are legendary. We're here to talk about the status of the law as it relates to the case as we last learned about it. So as we've learned from juror affidavits, we've heard from some jurors who say, actually, we were unanimous as to counts 1 and 3, at least in our own minds. But we weren't given an opportunity by the judge to relay that information and say we were unanimous. And so if we were unanimous as to not guilty, therefore, there should be a double jeopardy, right? Because we've reached a decision and that case should be over. Well, the Supreme Court of Massachusetts said not so much under their operative law. And so now we turn to the federal court for relief. Of course, the federal court can only grant relief under federal law. They're without any power to grant relief under state law. That's not what they do. They can only grant relief under federal law. So they can only do this if the federal law, namely the Constitution and the Fifth Amendment, requires it in sort of double jeopardy. So within the meaning of the double jeopardy clause, has double jeopardy occurred in a way that would preclude a retrial? That's exciting. So we turn our attention to the text of the case and we'll work our way through it on this issue. We are in a motion for writ of habeas corpus. Produce the body. Produce the body. Why am I being held? Why am I being prosecuted? I'd really prefer not to be prosecuted and held very much if you don't mind. Could you please step in, federal government? Okay. Now comes the petitioner by and through undersigned counsel and represents the following. Ms. Read is currently facing an April 1st retrial. The fact it starts on April 1st is perhaps the most appropriate thing about this trial I've ever heard. That is the most appropriate day to begin this criminal trial, April 1st, because it's a joke. Lol. So a start is scheduled to begin on April 1st. The petition contends that such retrial will violate Ms. Read's 5th and 14th Amendment protection. There's no real 14th Amendment protection as such. The 14th Amendment is simply the thing that incorporates the 5th Amendment right against the states. So the 5th Amendment, of course, initially only applied to the federal government. And the 14th Amendment was, what if we applied it to the states too? So there's not really a 14th Amendment right is as such, just merely the 5th Amendment now also applies to state governments. The petition relies upon post-trial statements of 5 jurors 4 directly and 1 indirectly, that the jury in Miss Reed's trial reached a final unanimous decision to acquit her of second-degree murder. Despite massive media publicity regarding these declarations, none of the other 7 jurors disputed the accuracy. Although that doesn't really mean anything, I'd just like to take note because, of course, as the judge correctly informed the jurors, they're under no obligation to talk to anyone absent a court order. So in the absence of a court order, they don't have to talk to anybody, and they might not want a piece of this. So we can't really infer anything from the fact that people are silent. Silence is not acceptance, so that doesn't really get you anywhere. But okay. In the usual course, the jury verdict would have been announced in open court, and re-prosecution for charge would have indisputably been constitutionally prohibited. Well, if they had said not guilty, then, so far so good, yeah. Here, however, the trial court, assuming but not verifying the juror notes, indicated impasse, referred to all rather than just several of the outstanding charges, failed to inquire pursuant to the relevant rules regarding the existence of any partial verdicts, as well as failing to poll the jury. And for that reason, the jury acquittals were not announced, and a mistrial was declared without consent. Okay, so for my money, here is the operative legal question. Is the court required to accept partial verdicts? So can the judge insist on complete verdicts or nothing? Can they do all or nothing? And my best understanding of the law is, yes, they can do all or nothing. That is a valid option. So it would only be an error legally. It would only be an error if the judge did something that she can't do, right? Where it either has to be one of two things. There either has to be a clear error of law, the law was violated, or there was an abuse of discretion, right? One of those two things. The law simply does not allow her to do this, or it technically does, but she really, really shouldn't have. So does either of those two things apply to the situation? To the best of my knowledge, I'm not aware of any federal law, certainly, that requires complete verdicts. And of course, we're in federal court, so we need a federal decision from a federal court that says you must have complete, that you can't insist on complete verdicts, right? We need some federal law that says you can't have an insistence on complete verdicts. If there are partial verdicts, the judge must accept them. And I'm simply unaware of any case that says that. So, if the jury thinks whatever they think until they have a verdict on all counts, can the judge be like, nope, all or nothing? Can the judge do that? To the best of my understanding, yes, they can. Okay, so was it an abuse of discretion for them to do that? And no, not really. I don't think so. I mean, the Massachusetts rules permit the judge to allow for partial verdicts. There is a comment to the rule, it's worth noting, that seems to suggest that it's mandatory, but as to what that means, as to what the comment to the rule means, that's purely a matter of state law because it's a state level rule. So whatever that commentary means in the state level rule is purely an issue of state law because it's a state level rule. So if you think it means, if you interpret that rule to mean the court must do that, there's only one person you can talk to, the Supreme Court of Massachusetts, because they're the only ones who can determine what the state law means. And in their decision, they didn't say anything like that. So it must not mean that. It must not mean as a matter of state law that the court's required to do that. The commentary to the rule must simply be a misstatement of the rule. It must be, because the Supreme Court of Massachusetts is the ultimate guide as to their own state law. There's nowhere left to go. It's the end of the road as to state law. So it must mean that. So, okay, so it can't mean that it's required as a matter of state law. So is it required as a matter of federal law? It's like, show me a federal decision that says it. I can't find one. Contrary to longstanding federal as well as state case law, if you show me a federal case, I'm interested. Let me know. The trial court gave no consideration to any existing viable alternatives to a mistrial, nor was defense consulted or given any opportunity to be heard prior to and in relation to the court's declaration of mistrial. They certainly were not given an opportunity to be heard on that third occasion. That's true. Although, of course, the defense could have objected, and I've taken umbrage with the defense's suggestion that they were surprised. Because once you give that deadlock instruction, we all know what's happening at that point. Every lawyer knows what's happening at that point, right? Either the jury comes back and says we're unanimous, or they don't. Either way, we're all going home, right? Either way, we're all going home. So it's like, we were completely surprised the judge declared a mistrial without giving out. Really? There's not a lot of there's not a lot of options here, man. There's not a lot of options. We were totally taken aback. I don't think so, but okay, sure. Anyways, at no time prior to the trial court's final sua sponte decision to respond to jury note by declaring a mistrial had the trial court even mentioned the word mistrial. I suppose not, but we all know what's happening. We all know what happens next in this play. Right. So the judge may not have said the word mistrial, but if you didn't know that by giving the deadlock instruction that mistrial was in the air, I don't know what to tell you. In these circumstances, the Commonwealth did not satisfy its heavily well-established burden of establishing manifest necessity as a condition precedent for the mistrial was declared in violation of petitioner's double jeopardy rights. Robin Rose says, what about Bev telling the jury not to fill out any verdict slips until they came to a decision? Well, that's what I was saying earlier, Robin. Can the judge do that? Is that something the judge can do? Is the judge allowed to insist on complete verdicts? And if not, what law prevents them from doing that? That's the question, right? What law prevents the judge from saying this is all or nothing? Give me all verdicts or give me none. And I don't know of any law that prevents the judge from doing that. So what do you want me to do? There's no law that seems to prevent it. Maybe they'll cite some, but I'm not aware of any. What about the cop who oversaw the jury? Why not use the court clerks or staff? He's very close to suspicious witnesses. Those are evidentiary issues, pro gamer, with respect. Those are evidentiary issues, and we're not here on any of those issues. We're here simply as a matter of law. We're here on the legal posture of, given what we know, can we do this? And none of the things that you just mentioned are in this complaint. So if they're not in the complaint, they don't exist, right? Courts can only adjudicate based on the docket that's in front of them. We're in a federal proceeding now. As of this moment, this document, I think, is the only document that exists in this proceeding. So within the confines of this case, none of the things you say are true because they don't exist within the confines of this case because they're not within the legal docket. So we can only adjudicate based on the information that's available within the docket because that's what the federal judge is going to do. The federal judge is only going to adjudicate based on the things that they know about. And so none of the things you mentioned are true within the confines of this case. But I appreciate your question. All right, let's see what's going on. Where were we? Okay. Defense independently maintains a jury's final unanimous agreement that Miss Reed is not guilty constitutes an acquittal for double jeopardy purpose, and that the trustworthy and uncontradicted post-trial affidavits entitle her to a minimum at judicial inquiry on the issue. It would only entitle her to an inquiry if it would matter, right? Because we're here on a pure legal posture, right? You're only entitled to an inquiry if the result of that inquiry could result in something. Right? Is it relevant? And whether or not it's relevant or not is a question of law. So unless the judge was required to do something they didn't do, there's no point in asking the jurors because we can just assume that we can just assume it's true for the moment. We can just assume that they were 12-0 in their own minds as to those counts. We can assume it and say, well, given that, does it matter? And if the answer to that question is no, it doesn't matter, then there's no reason to confirm it's true because it doesn't matter. So fair enough. The prosecution wants this court, in essence, to ignore the declarations of the jurors, ignore the possibility, if not the probability, the jury found unconditional and finality without any ambiguity, unanimously found Miss Reed innocent, and to avoid post-trial inquiry that could demonstrate that all 12 jurors rejected the sufficiency of the prosecution as to 2 or 3 indictments. Okay. The defense has more than met its burden of production regarding the jury's decision to acquit. Not unless it matters. Not unless it matters. That we have to, it presupposes it matters legally. Neither the trial court nor the Supreme Court held otherwise. Of course they didn't, because they took it as true. They assumed it to be true, and they're like, even given the assumption, it still doesn't matter. Instead, the state courts erected an impermissible procedural barrier to prevent Ms. Reed from proving what's clearly true. The juries finally and unanimously agreed that Ms. Reed did not commit the murder, nor a second charge of leaving the scene for which she stands charged. The ruling is irreconcilable with the constitutional interest in having decisions by jurors respected and honored. Public respect for the judiciary requires that agreements reached by a jury of defendants' peer in a manner so consequential not be rendered irrelevant. Well, the consequentiality of it, I'm not sure is necessarily material. I mean, the rule is the rule, regardless of how serious it is. I mean, unanimous juries are required in, all criminal cases. So I'm not sure that this is particularly serious necessarily changes the analysis, but okay. For these reasons, federal courts favor a voir dire, and the denial of such an inquiry has violated Ms. Reed's 5th, 6th, and 14th Amendment rights. Okay, we're going to skip the procedural background because you guys know the background. We can skip all that. All right, let's see what we got. Because Ms. Reed is currently released on bail, she's in the Commonwealth custody as required to file law. Fine. She's on bail, so she's within custody enough for the purposes of federal law. I'll take that to be true. The First Circuit has made clear that a petition for habeas that raises a colorable claim of former jeopardy need not invariably await trial and conviction in state court. Such claims are distinctive because the Constitution insists that courts may not impose more than one punishment for the same offense, and prosecutors ordinarily may not attempt to secure that punishment for more than one trial. All right, let me tell you why they just said that just now. In federal law, there's this thing called abstention doctrine, literally from the word abstain, as in not doing a thing. So under certain circumstances, the federal courts abstain from hearing cases. And one of the bases for which they do that is, for example, ongoing live state proceedings. Ex parte Young, by the way, as one such case that's very notable in this area from the US Supreme Court, if you want to look it up later on your own time. But the Supreme Court has basically said, in so many words, there are certain circumstances in which federal courts should not hear cases, even if they technically could. Okay? And one of those situations in which the federal court does not tend to hear cases is when there is an ongoing live state case. One of the reasons being which, incidentally, is this idea of separate sovereigns. States are sovereign. The federal government is sovereign. And so the state has the right to conduct its criminal proceedings. And the federal government's power here is extremely limited. And so they tend not to like to get involved in state level proceedings while they're ongoing, because they want to, for example, give the state the ability for the state to, of course, get it right on its own merits. And they, of course, don't want to necessarily get involved while things are ongoing. They prefer to sit by and watch. So they're citing this case from the First Circuit to try to get the federal court to say, no, you can step in this circumstance. It's okay for you to step in and hear this case. You can do it. My best opinion is I think it's more likely than not the federal court will not hear this case. I think it's more likely than not the federal court is going to abstain. Yes, there is some situation in which you technically can, but I don't think they're going to exercise the discretion to do so, even if they technically can. So my money, I think the odds are better than not. The federal court simply refuses to hear this case on abstention doctrine. But the reason that they're citing this is to say to the federal court, you can do it if you want to. It's okay. Yeah, I don't know that that's going to work, but you gotta give it a try, I guess. But good luck. As the Supreme Court has observed, the rights conferred on a criminal accused by double jeopardy would be significantly undermined if the appellate review of double jeopardy claims were postponed until after conviction and sentence. To be sure, the double jeopardy clause protects an individual against being twice convicted for the same crime, and that aspect of the right can be fully vindicated on appeal following a final judgment. However, this court has long recognized the double jeopardy clause protects an individual against more than being subject to double punishment. It's a guarantee against being twice put to the same offense. Fair enough as far as it goes. And incidentally, by the way, This all gets back to what is your federal hook, right? For this being double jeopardy. This all, of course, presupposes this is double jeopardy as a matter of federal law, and you're going to federal court. So it needs to be double jeopardy as a matter of federal law. So if it is double jeopardy, then, the federal court can intervene because it's double jeopardy. But why is it double jeopardy, right? What is your federal law that says this is double jeopardy? And you haven't cited any. You're just like, if it's double jeopardy, you can step in. And this is totes double jeopardy, though. Yeah, but why? Why is it double jeopardy? What is the precedent? Why was the court required to ask for partial verdicts? Was the court required to ask for partial verdicts? When they came back and said, we're still hung, was the court required to say, what I really want is some partial verdicts right now? Could you do that? Were they required to do that? Or was the judge allowed to say this is all or nothing? And if the judge is allowed to do it, it's not an error of law. If they're allowed to, it's not an error. And if they're allowed to, then it's just an abuse of discretion. And do you know how hard that is on an abuse of discretion analysis? It's pretty hard. So, not so much. So what is your federal hook here? Obviously, these aspects of the guarantee protections would be lost if the accused was forced to run the gauntlet a second time before the appeal could be taken. Even if the accused is acquitted, or if conviction has the conviction ultimately reversed on double jeopardy grounds, they've still been forced to endure trial, which is true as far as it goes. And incidentally, this is one of those few occasions where you're allowed to do an interlocutory appeal. You're allowed to appeal before there's a final judgment, because the whole thing is if you're entitled to double jeopardy immunity, then being put on trial is the very thing the double jeopardy immunity is meant to prevent. So it doesn't make any sense. The normal rule, of course, is we wait till the end of the trial, then you can appeal. You can't appeal until the end of the trial. But this, of course, is an exception to the rule because the injury is non-remediable, right? The appeal court can't fix it because the injury would have been you being forced to undergo the trial, which has now already happened. So that makes it an irremediable injury. It's non-remediable. They can't fix it. So since they can't fix it, the only thing we can do is to have the appeal before the trial happens, because then the Court of Appeals can fix it by preventing the trial from happening, which is the very thing you're entitled to. So you're allowed to appeal this issue. And she's had her appeals. And now she's going to the federal court and being like, how about you want to step in as a matter of federal law? So she can certainly do it. She can certainly ask it, but she needs the federal hook for the federal court to ask. She needs federal law for the federal court to act. So, okay, let's see if we got anything. For these reasons, the defense contends that the retrial on counts 1 and 3 would violate the double jeopardy protections. Accordingly, they may seek federal habeas corpus relief without first undergoing trial. That sounds right to me, of course, but you still need a federal cause of action. You can seek relief, you just need a federal hook. Okay. We will skip the facts because we know the facts and we've discussed the facts many times. You know the facts. The court sent the jury away 3 times. The second time they said, deadlock instruction. Can you really please try pretty please to figure this out? The third time the jury said, nope, we're kind of stuck here. We can't figure it out. The judge read the note and be like, okay, how about mistrial? Without hearing from anybody. And then everyone went home. We all know the facts. We got it. We don't have to do the facts again. We got it. It's fine. So we'll skip the facts because we know them all too well. Skip. All right, great. Reprosecution of counts 1 and 3 will violate Miss Reed's double jeopardy rights. Okay. Because Miss Reed is awaiting trial on state criminal charges, she is non-custody. Fine. Accordingly, this petition is brought pursuant to some section of law, not some other section of law. Also fine. The restrictions on the scope of habeas do not apply. Fine. Instead, the court must defer to the findings of fact. Of course it does. The federal court must defer to the findings of fact. This isn't a trial. It's a habeas relief. We're here on a pure issue of federal law. So the facts are what they have been given. Cool. But instead must take a plenary review of that court's resolution of the issue of law. So we're here on a pure issue of law. Habeas petitions governed under some section of law are not subject to the heightened standards contained by some other section of law. Ordinarily, a motion to dismiss on double jeopardy grounds rests on a pure issue of law, that's de novo. As to the federal law, sure, why not? As to the federal law, sure, why not? Yeah, the federal court has the power to review the federal law de novo. The state court has, of course, hopefully done its best, but the federal court, of course, is ultimately in charge of federal law, just as surely, incidentally, as the state court is in control of state law. So this does, of course, go both ways, and that's important to remember. The federal courts have no power, zero, to change or modify state-level law. It is taken as a given. And they can only say, given that state-level law, it's in conflict with the federal law. But they are without power to provide their own exciting interpretation of state law. Only the state-level authority can provide the state-level guidance. Now, federal courts, to be fair, from time to time, when there's a gap, will try to guess what the state court would do. But they're just trying to guess. And incidentally, that will happen in other circumstances where states will sometimes adjudicate other state issues. For example, a contract proceeding or a choice of law proceeding. So I'm suing you in some state, but I'm suing you under some other state's law. That can happen, right? I'm suing you in Michigan, but I'm suing you under California law. That can happen. So what does the Michigan state court do? Well, they're going to apply the California state court decisions because they're, of course, without power to change those decisions. It's a Michigan state court. Why would they have any power to change California state level decisions? That'd be incredibly dumb. But they're going to do their best. And if there's a gap, they're going to try to do their best to figure out what California would do. Like, I'm going to put on my California state law hat and do my absolute best to think what they would do. That's what they're supposed to do. So anyways, that's what they're talking about. So fine. The ancient right to a jury trial is not a mere procedural formality, but rather a fundamental reservation of power. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretend offenses and arbitrary convictions. Prominent among these reasons the colonists cited in the Declaration of Independence for their break with Great Britain was the fact that parliamentary and the crown had deprived them of many cases. This isn't necessarily the greatest signal, by the way, that for a case. Incidentally, when you're starting off with this really high level stuff, when you're starting off with these really sort of grandiose, high level pronouncements about this sort of stuff from the sort of 30,000 foot overview, it's not exactly super encouraging. Right? It's because I don't have something more specific to work with. So I'm just going to start telling you about why America is great for a while. America is great. It's a wonderful country, and we should all feel great that we live in America. America rocks. As true as that is, it's not super encouraging with respect to the specifics issues at hand. So America may in fact be awesome, but do you have anything a little bit more specific for me, counselor, would be helpful. After securing their independence, the founding generation sought to ensure what happened would not happen again. As John Adams put it, the founders saw a representative government and trial by jury as the heart and lungs of liberty. Very aspirational. It follows that the jury acquittals entitled to the utmost respect in our criminal justice system. The double jeopardy clause provides that no person shall be subject to the same offense be twice put in jeopardy of life or limb. Very true. Robin Rowe asks, when Bev essentially told the jury all or nothing with the slips, would it have made a difference if the defense objected? Sure. Otherwise, Karen Reed couldn't be acquitted on counts 1 and 3. Sure. So, apologize. If the defense wanted partial verdicts as an option, they could have, of course, asked for that at many times, including, incidentally, and perhaps most importantly, for my money, when the jury instructions were being written, right? Because those are the rules. Those are the rules. And those are the rules that are given to the jury. And so the most operative time for the defense to say we would like partial verdicts would have been when the jury instructions were being written. because otherwise the defense or the prosecution, as the case may be, might be asking for it because based on the notes or based on their street sense or based on their Ouija boards or based on whatever tools they're using in their own personal time, they think the jury is leaning their way, right? So what we kind of don't want to have happen is either the defense or the prosecution, as the case may be, depending on which way they think the wind is blowing, suddenly being like, you know what, all of a sudden I'm super interested in partial verdicts. I wasn't really that interested in partial verdicts before, but the crime scene has talked to me. Much like Trooper Paul, the crime scene has talked to me, and the crime scene has told me that partial verdicts are now in my interest. So would you like to, maybe ask for partial verdicts now? I, as a judge, would have been like, why didn't you ask this when we wrote the rules? And you probably would have said, because the crime scene hasn't talked to me yet. And I would have been like, lol, no, get wrecked. So yes, the defense could have asked for partial verdicts. Most importantly, it will be really interesting, incidentally, by the way, this will be a really interesting tell, because I don't think the defense is going to do it, but we'll be wrong. We'll see if I'm wrong, because I'm predicting what's going to happen in the future. It'll be really interesting to see when the new jury instructions are being written for the new jury. It'll be really interesting to see whether or not the defense is interested in partial verdicts at that point or not. That will be really interesting, right? Will the defense say, you know what, we're really interested in partial verdicts. We'd really like partial verdicts now. I don't know, man. I don't know if the defense will do it. I guess we're going to find out. It should be exciting. But if they don't say that, then that will somewhat have belied all this, right? If we get that far and they don't ask for partial verdicts, it would have somehow belied, yeah, we were really interested in partial verdicts. That's what we wanted the whole time. Sure it is. Let me know. We'll see. Okay. The underlying idea is one deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state with all its resources and power should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which they may be stigmatized by the unresolved accusation, and may even enhance the risk that an innocent defendant may be convicted. Very high level stuff, all appreciated. Okay. Reprosecution is barred because there's no manifest necessity to declare a mistrial on which the jury was not deadlocked. Okay. As a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. This rule is rooted in we're still at high level, by the way. I'd like to take note here. This rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of the tribunal she believes might be favorable to dispose of her fate. Thus, after mistrial has been declared, without the defendant's request or consent, the permissibility of a retrial depends on manifest necessity. True enough, one of two things is going to happen, right? If we're going to declare a mistrial, one of two things, right? Either the defense asks for it, in which case it's consensual, or we had to do it because of manifest necessity. The jury was threatened. The jury was bribed. The judge was threatened. The judge was bribed. The jury is hung, or, other sort of, act of God kind of things, or something has gone catastrophically wrong somewhere along the line and we need a redo. So some sort of thing has happened that is way outside of what we are used to dealing with, and so we need a redo. Cool. The power to discharge a jury without a verdict ought to be used with greatest caution under urgent circumstances and for plain and obvious cases. Fair enough. Importantly, the burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. True enough as far as it goes. The government has to prove manifest necessity. If not consent, then because we had to. And who has to prove because we had to? The government does. No problem with that. And they say it's a burden that the state court erroneously put on the defendant. In assessing where the prosecution has satisfied its burden, the First Circuit has stated it's useful to consider the following three factors. Whether the trial court consulted with counsel, whether the court considered alternatives to mistrial, and whether the court adequately reflected on the circumstances before making a decision. Please take note, by the way, these are factors that are listed. They use the word factors, right? Not that these are dispositive. So here's some things that you might want to look at in trying to make this decision. Does that necessarily mean if these things didn't happen, it isn't a manifest necessity? No, it doesn't mean that. It's just like, here's some factors that might be indicia that you could use. Okay, cool. Embracing both consideration of alternatives and consultation with counsel is the amount of time devoted by the judge to the mistrial decision. A precedent decision reflected by rapid sequence of events culminating in declaration of mistrial tends to indicate insufficient concern for defendants' constitutional protections. Fair enough as far as it goes. Okay. And that cites Brady versus Samantha from the First Circuit. Although in other circumstances, a reviewing court may defer to the trial court's discretion to maintain a mistrial decision. Okay, and so right here, they talk about discretion, right? And so the trial court's discretion. So like, yeah, one of two things, right? Clear error, I can't do it. Abuse of discretion, I really shouldn't have. So if this is discretionary, if this is discretionary, and we're here on an abuse of discretion standard, I don't see it. I don't see abuse of discretion, not under these circumstances. And of course, it's circumstance specific. So I don't see abuse of discretion, not here. If the record reveals the trial court has failed to exercise sound discretion, the reason for such deference disappears. Yeah, if it's an abuse of discretion, then fine, but yeah. Here, the Supreme Judicial Court at the outset committed legal error. Well, which is it? Right? Which is it? Is it discretion or is it legal error? Those are not the same thing, man. Which is it, right? Here at the outset, the Supreme Judicial Court committed legal error by relying heavily on upon the trial court's discretion, notwithstanding the record revealed no consideration of any alternatives. Is that legal error? They were required to? Why? Why were they required to? I mean, you referred to the factor test, but why? No. Turning to the relevant factors, which are factors, the first thing to be noted is the trial judge did not give counsel an opportunity to object or discuss with them the availability of mistrial. Upon receiving the final note, the court declared a mistrial and excused the jury without consulting counsel. Yeah, this situation is not really is sort of not really what we're talking about. And when we talk about that, there have been situations in the past where a judge just kind of out of the blue declares a mistrial when it's unexpected, right? And just says, "Oh, mistrial now," and everyone's like, "Wait a second, what happened?" Right? So there have been situations when judges have just said, how about mistrial? And everyone's super confused. And then, the right of the defense to be heard when it was completely unexpected, this shot from the blue, this shot from the dark, obviously is more manifest because the defense had no idea. But this situation isn't really that situation. It's like once you give that Allen charge, or as Massachusetts has decided to call it, the Tui Rodriguez charge, because they're not all about that Allen charge life. They'd really like to call it the Tui Rodriguez charge. But once you give that deadlock instruction, no matter what name you give it, it isn't a rose by any other name, just a sweet lol. Once you give that deadlock instruction, it's like, look, we all know what's happening. We all know what the game is. So for the defense to try to claim we were totes surprised that the judge said mistrial, I'm like, really? Really, were you? Were you really totes surprised? Especially given the other notes, which seemed fairly emphatic. And that you were really caught off guard on that one. You didn't have the opportunity to say, I object, or I want to be heard, or I have some thoughts on the subject. Really? I don't know, man. I don't know. Video footage reinforces the suddenness of the action, sure, and corresponding lack of any meaningful opportunity to be heard. I'm not sure about either of those things. At approximately something on the video, the court took the bench instead. The jury is at an impasse. In contrast to procedure followed as to prior notes, the note was not read to counsel. Instead, the court immediately called for the jury to be brought in. The sound of the door opening and closing can be heard at the video. A mere 30 seconds later, the jury arrived. Well, it's 30 seconds that you could have stood up and said, "Can't we have a sidebar?" Or can't we have a meeting? I mean, you had 30 seconds, man. You had 30 seconds. The Jeopardy music was literally playing. Lol. The most appropriate time for the Jeopardy music to ever be playing in the history of ever. The Jeopardy music was playing in the courtroom. I remember hearing it. And you didn't have your answer down on the page in time. The court then read the note, which had not been previously read on the record. At something the court stated was declaring a mistrial and immediately discharged the jury a mere 7 seconds later. These circumstances not provide Reed counsel with a meeting opportunity to be heard. I'm not feeling it. Legal and factual context renders the trial court's action even more unexpected. Okay, please tell me why it is more unexpected than it seems. Legally, trial counsel was entitled to rely on decades of case law, explicitly requiring a full opportunity to be heard before the declaration of a mistrial. Yeah, but one of the things is, like, wasn't there sort of a full opportunity to be heard in the previous notes? Because in the previous notes, you had said, I want, what is it you had said? You said you wanted the deadlock instruction, right? And then the prosecution's like, no, keep going. So, like, we kind of all know what's going on here. And it's like, okay, I mean, what could you have possibly said? And so also one of the things also from a legal perspective is, why did it matter? Why did it matter, right? We're looking for an error that matters. We want, or otherwise we talk about harmless error. We hear that in law a lot, right? Harmless error. So let's presuppose it was an error for the judge not to ask that. Okay, I'm not really sure it was under these circumstances, but let's go with it. All right. So it was an error for the court to not hear the defense. Okay, fine. Why does that matter? What would you have asked for? And if what you would have asked for was, well, we'd really like partial verdicts now, the judge could have simply said, well, the rule says may, how about no? Right? And so why does it matter? Because the judge could have just done that anyway. So it's harmless. It doesn't matter. It doesn't materialize in the real world. You know, it doesn't materialize in the real world. They never discussed polling the jury, but yeah, but like, what if the judge had just said no? See, that's the thing, right? What if the judge had just said, no, I'm not going to do it because I don't want to. So yeah, we're sort of back to, can't the judge insist on complete verdicts? Is that a thing the judge can do? Can they insist on complete verdicts? Can they be like, nope, all or nothing, everything or nothing? We're not doing this in pieces. Can they do it? And if not, why not? What prevents them from doing it? So what if the judge said no? Now what, right? Right? Why they use the word may? Because it's discretionary. That's exactly why they use the word may, as opposed to shall. Yeah, there's a very big difference between shall and may. Right? When you say may, it's because it's something you can do. When you say shall, it's something you have to do. So when it says may, it's like, oh, okay. Well, all right. Nice to know. It also deprived defense counsel of opportunity to raise issue or even discuss potential remedies with their client. See, again, for my money, no, because you could have been discussing that the entire time when the jury was away with their deadlock instruction. Because again, it's like we all know what's happening. You had so much time to talk and confer with your client about it. It's like either it's deadlocked or not, right? And so you had so much opportunity to confer with your client on this issue. I'm taking umbrage at the surprise argument. Moreover, defense respectfully submits that given the importance of the double jeopardy protection and profound implications of a retrial, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity to consult with the client. Counsel for Ms. Reed clearly had no such opportunity. But didn't they, though? Didn't they? The Supreme Judicial Court erred in multiple respects in ruling the trial court's prior consultation with counsel was sufficient to excuse the absence of such consultation at a pivotal moment. Okay, why? First, the Supreme Judicial Court erred in relying on the trial court's solicitation of counsel's view in response to the first two jury notes. Those discussions relate solely to the propriety of giving the deadlock charge, which is designed to urge the jury to reach a verdict, and presents a distinct legal issue from the declaration of mistrial. Yeah, but once that charge is given, though, defense counsel's request for the charge implies their desire was not to have a mistrial, but instead have the trial court urge the jury to reach a verdict. Yeah, but once you give the charge, though. Yeah. Second, the Supreme Court Judicial Court was wrong in simply asserting that consultation regarding the third note would not have produced any fruitful alternatives. This reading of the silent record against the defense is contrary to current case law, placing the burden of establishing manifest necessity. No, I disagree. Right? Because it's like, well, does the error matter? If it is an error, does it matter? And so they're like, okay, you say that this was a mistake. Why? And defense says their reasons, and like, yeah, we don't think that mistake matters. So the prosecution's like, jury's hung, though. That was the manifest necessity. Jury's hung. And you're like, but we wanted an opportunity to be heard. Okay, why? Here's why. Okay, it wouldn't have mattered. So they proved the jury is hung. They proved their burden. And you haven't proved why there was a mistake. So, yeah. Moreover, as set forth, there were alternatives to declaration of mistrial, so it's far from clear the consultation would not have proved fruitful. The record is independently lacking on the second prong as it reflects 499 from Crispy. I think that's Crispy. I'm going with Crispy TY. 499. Lesser included as incomplete verdict seems prejudicial, no? No, it depends who you ask, I suppose. Couldn't the prosecutor use that to try a defendant over and over? Well, assuming that a jury is unable to reach complete verdicts, I suppose, yeah. But whether or not it's prejudicial, I don't know. Depends on your point of view, I suppose. There might be reasons the defense wants complete verdicts. Right? Partial verdicts don't necessarily favor the defense inherently. Partial verdicts might favor the prosecution inherently. I'm not sure, on the psychological zeitgeist on that, but if I were a betting man, I'd be willing. I think partial verdicts probably favor the prosecution on balance more, because it creates a better ability for the jury to compromise. All right, it creates more of an ability for the jury to compromise. It's like, can we at least agree on count whatever? Can we at least agree on count 2? And so it creates more opportunities for an escape ramp. And so I think it might be true, although I'd be willing to be corrected that I'm wrong on this issue, because this is an issue of psychology more than anything. So it's a little bit outside my area of expertise. But if I had to bet, I think on balance, partial verdicts probably favor the prosecution more on balance. So I couldn't swear to it. There might be reasons the defense wants it, but I don't know that it's inherent, but I appreciate your question. Yeah. It's also, of course, worthy of mentioning, by the way, and I've said this before on multiple occasions, when we're talking about the rules, we have to make sure that we're being very consistent with our application of the rules, because we want to be fair. We want the rule to be the rule, right? We want the rule to be the rule. It can't be because our team is winning or losing that we suddenly don't like the rule very much. And so I've commented about this before. It's like, okay, presuppose that in reality, the 5 jurors who swore their affidavits or whatever it is they're doing, suppose those jurors said, nope. On counts 1 and 3, we were guilty. We were guilty. We were as convinced as the day is long. We were totally convinced, 12-0, she was super, super guilty. And we were 8-0 on 8-4 on guilty on count 2, but we just couldn't get there. We just couldn't get there. And so, right? And so, like, should it be the rule that counts? Should it be the rule that counts after the fact? Should it be the fact that, wait a second, now the prosecution is filing their motion and says, wait a second, they were guilty, lock her up, right? So how do we deal with that reality? The rule has to be fair both ways. The rule has to be fair both ways. So I caution my friends who, like me, are in the pro Karen Read community, because I think Karen Read is factually innocent, and I think the case is bullshit on the evidence. So I caution my friends who are in the pro Karen Read community that, be careful for what you wish for. Be careful what you wish for, because you might just get it. And that can be a problem, man. The record, where were we? Okay. In fact, the reporters know, the record independently lacking on the second prong, as it reflects no judicial consideration of the alternatives to mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked, and or to ask the jury whether or not its final note related to all the charges. Yeah, but see, the thing is, you have to make that decision without knowing the result. That's the thing, right? That's the thing, right? You have to make that decision without knowing what the answer is going to be, right? So the defense is like, they totally should have asked. They totally should have asked, because the answer was not guilty. Yeah, but you only know that now. You only know that now, that the answer was not guilty. You didn't know it then. Were you perhaps a little bit more skittish? Were you perhaps a little bit more uncertain about partial verdicts then than you are now? Were you a little bit more uncertain then than you are now? I bet you are. I bet you are. I bet you have a lot more confidence that they should have asked the jury now than then. What has changed? What has changed that has changed your mind so radically? Oh, we know what the answer was, and the answer is in our favor. Yeah, that's an invalid reason, though. That's an invalid reason. Brendan White says, do you think this filing will attach Alan Jackson to her case more permanently in the view of what might happen? No. I mean, he's already as attached to the case as one can be. So I don't think it's going to become more attached. He's firmly attached. He's a barnacle on this ship, man. He's attached as we're going to get. This option is apparent from the face of the Massachusetts rule, which states that the judge may declare mistrials to any charges on which the jury cannot agree, provided, however, the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. In fact, the reporter's notes expressly indicate that the receipt of such partial verdicts is required before the mistrial may be declared for manifest necessity. See, for example, the note, which says this rule also provides the court may declare a mistrial in cases in which the jury is unable to reach a verdict. However, it must first receive and record verdicts on which the jury can agree. Now, you might be saying to yourself, oh, geez, that seems pretty clear to me. All right, I would say two things in response to that. First of all, the notes do not overcome the rule. Right? The rule is the rule. The notes are commentary to the rule. Right? So the notes do not supersede the rule. The rule says may. The notes say must. I don't know why the notes say must, because the rule says may. So I think the notes are a mistake. So I would not interpret me as a judge. I would not interpret this to be must, because the commentary to the rule says must, but the rule says may, and the rule beats the commentary. Okay. Second of all, whatever that rule means is a matter purely of state law. It's a matter purely of state law. So the Supreme Judicial Court could have said, no, the rules must. The commentary says must. The rule is must. You were bad. You were bad for not saying must. Must is the thing. Must is the way to go. But That's a question for the Supreme Judicial Court of Massachusetts, period. End of discussion. The federal court has zero power to change the state Supreme Court's interpretation of its own state law. All the federal court can do is say, given that interpretation, there is a conflict with the federal law. So what's the rule? The rule is may. The rule is may. The Supreme Judicial Court didn't say anything different. The rule is may. So I'm super thrilled with you citing the commentary to the rule, but there ain't anything that this court can do about it because it's not a state court. We're in federal court with federal law, man. Separate sovereigns. The state of Massachusetts is sovereign. It is God as to its own law. I mean, because that's the nature of federalism, which is a good thing, incidentally, in my view. I'm very strongly in favor of federalism. Federalism is good. So, yeah, that's not right. Had the court inquired as to the existence of partial verdicts and the jury articulated its verdict consistent with the statements of A, B, C, D, and E, the double jeopardy implications would have been clear and divisive. Yeah, if wishes were horses and so forth and so on. Yeah, if they had and wishes were horses and candy and nuts and blah, 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 whatever. Indeed, with virtual unanimity, the courts have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. Yeah, true enough, if there had been a verdict, yeah, collateral estoppel is definitely a thing. Yeah, you can't bring a proceeding that substantially relates to the same proceeding and not be attached to those facts. So once this jury had declared not guilty, they are ruling on the facts. Because that's what juries do. They rule on facts. And so those facts are now locked in time. And so the state can't bring a prosecution that would be like, but those aren't the facts though. But they totally are now. Those. So you can't bring another proceeding and be like, I want to charge her with some new exciting crime that are dependent on the same facts. No, the facts are locked. There's nothing for a new jury to do. There's nothing for a new jury to do. A jury has determined the facts, you're locked with it. So yeah, collateral estoppel is certainly a thing if there had been a verdict, but not so much. When a jury hands down a partial verdict, a final judgment is rendered onto which the jury had reached agreement. Yeah, if that had happened, that would have been nice. The First Circuit's decision in United States versus Toribio Lugo provides a helpful analog. There in the midst of trial, upon noticing that only 11 jurors were present, the district court consulted with both the prosecution and the defense lawyers, outlining two options: either postpone the trial until the 12th juror could be located, juror missing, or proceed with a jury of 11, which, by the way, is explicitly allowed under the federal rules. They're allowed to proceed with a jury of 11. It's in the rules. So that would have been fine. Defense counsel conferred with client and informed the judge the defendant did not wish to proceed at that moment with 11 jurors, but rather would like to wait for the 12-member jury. Shortly thereafter, the judge learned for the first time the missing juror had been absent during some or all the portions of the trial. How the judge is just learning about this for the first time is beyond me. Did they not notice this person was missing from the jury box? Lol. But apparently we're just now figuring it out somehow. This juror also hasn't been there other times. Very observant judge, I see. Exciting. The judge then announced that they were going to declare a mistrial because only 11 jurors had heard the evidence and did not believe there was any way to cure the defect. The trial judge denied a subsequent motion to dismiss on the grounds that mistrial was required by manifest necessity because only 11 members remained and the defendant had refused to proceed with fewer than 12. Yeah, the error there by the judge is, I already know the answer to this question. Right? The error there by the judge is that the federal rules allow for juries of 11. So the judge is just not doing very good at their judging today. They're not noticing that jurors apparently aren't showing up to court. That's exciting. And they're also apparently unaware of the rules that allow for 11-member juries. That's a thing that you can do. And they're like, I don't see any way we can proceed with 11 members, but the rules say it's okay. I don't see how we can do it. But it's fine. I don't see what we can do. The frustration continues. The frustration continues. The First Circuit revealed finding there was a clear alternative, proceeding with 11 jurors. Yep. While the district court had tentatively explored the alternative, it never exhausted it. The court never offered the defendant the choice proceeding with 11 jurors or accepting the mistrial. In fact, during pertinent time frame, the court made no effort to discern the defendant's attitude or wishes regarding the possibility of a mistrial. Didn't ask what the client wanted. That was good news. In view of these omissions, the record compelled a conclusion that 11 was not adequately explored. Yeah, this judge doesn't seem like they're necessarily completely with it. So that sounds fine. I'm cool with that conclusion. I'm not sure it necessarily applies here, but I appreciate it anyway. It was a fun story. This conclusion was dispositive because where there had been viable alternatives to the mistrial and the trial court failed to adequately explore it, a finding of manifest necessity cannot stand. So I suppose there was a viable alternative here because the judge could have at least theoretically asked for partial verdicts. So they didn't necessarily fully explore the space. Okay, maybe there's an idea there. I'm not sure this one precedent is going to get you home, but at least it's something that's a little bit more tangible than what we've been discussing so far. So at least it's a little bit more, there's a little bit more something there than what we got going on. We're on page 21 and we found the first thing of substance, which is not really great, but okay. The present case reflects even less consideration of alternatives. While the trial court discussed the two prior jury notes reporting impasse, it did so only in the context of deciding whether to give the deadlock, and the court did not even mention the prospect of mistrial. The Supreme Judicial Court therefore legally erred in finding the trial court response to the first two notes reflected adequate consideration of the alternatives to the mistrial. There is nothing in the record to indicate the judge was considering mistrial at that time. I mean, once the instruction is given, I think everyone's considering mistrial. I mean, come on. While the note stated the jury had reached an impasse on some charges, the test is not whether the jury considered that she had potential problems on her hands, but rather whether she had accorded careful consideration to the defendant's interest in having the trial concluded in a single proceeding. With a record barren of any hint whatsoever the judge was aware of double jeopardy implications of their decision, the defense respectfully submits this court cannot find the discretion was sound. Yeah, I don't know. And also, the federal court is not going to go out of their way to relitigate any issue that you did or could have raised to the Supreme Court of Massachusetts. So one of the things the federal judge is going to want to know is, did you raise these issues? And did you adequately give the Supreme Court of the state a chance to rule on these issues? Because, that's one of the things they're going to want to know the answer to. And if the answer to that question is no, they didn't give the Supreme Court of the state a chance, the federal court is not going to save your ass. So in addition to everything else, they're going to want to know, did you even give the state a chance, the state Supreme Court a chance did you even give them the chance? Yeah. What the record barren of any hint whatsoever, the judge was aware of the double jeopardy implications, defense respects that discretion was sound, or the court finds it cannot find it was sound. Okay. The statutory prohibition on ordering the jury to continue deliberations without consent was among one of many factors the trial court should have considered in consultation with the parties. I have a very hard time believing, as a matter of fact, I mean, obviously no one can know for sure because we can't do the counterfactual, right? We can't live in the alternate universe where this happened. But I have a difficult time believing that if the judge had been like, okay, I'm thinking about declaring a mistrial, what do you want to do? I have a really hard time believing the defense would have said, we want partial verdicts. I have a difficult time believing that. They're saying it now because they know the answer, but I have a real hard time believing they would have said it. And I think it's going to, again, be very, very telling when we get to the new trial and see what the defense asks for the jury instructions. It'll be really, really interesting to see when the judge says, so do you want partial verdicts or not? What the defense says when they're writing up those jury instructions. A court does not err if it asks about a partial verdict, even where it's clear the jury is at an impasse and further deliberations would be fruitless. Moreover, it wouldn't have been an error because the rules allow for it. It wouldn't have been a legal error. It's possible. Moreover, the trial court could have alternatively informed the jury. It could not be required to continue deliberations without consent and still asked it to retire to consider whether it was prepared to return a partial verdict. Possibly. But, that's a very sort of disfavored thing, as the Supreme Court pointed out, and I think quite correctly. When you ask juries to do that, you're like, can't we salvage something out of it? It's mostly been defense lawyers who have been saying, you shouldn't do that. Because when judges in the past would be like, can't you salvage something? It's usually the defense lawyers who have been objecting and going to courts to say, you can't do that. So the shoe is a bit on the other foot in this circumstance, but okay. Thank you, by the way, for the 722 of you who are currently watching. I do appreciate it. If you wouldn't mind hitting the like button, I'd also appreciate that. It helps with the algorithm. The algorithm seems to like the like button. And by the way, you can join for a mere 99 cents a month. It's literally as cheap as YouTube will allow me to charge you. You join for 99 cents a month and become an uncivilian. You get a cool little icon by your name and you get your name in green. Plus, you're not subject to the time requirements when the chat gets busy. If we need to up the time requirements, you're not subject to that. And plus, you get behind the scenes content, such as my gaming streams or when I do like offbeat streams or when a stream goes off the rails, as sometimes happens recently. And I'm like, this stream has went off a little bit off the rails, so I'll make it members only for the people who really like that kind of thing. So if you're interested in the errata and behind the scenes content, 99 cents. Plus, of course, you get that feeling of just that little bit, a feeling of being just a little bit better than those who aren't uncivilians because you support a creator that you love. And your support is, of course, appreciated. Thank you, Christy, for the gift memberships. You get cooking streams. You get cooking streams sometimes. That's very true. The dispositive fact for the present purpose is the record provides no indication the trial court even considered the available alternatives. Cool. While the law is clear that a jury deadlock may constitute manifest necessity, the key to the principle is that the jury must be genuinely deadlocked. They seemed pretty genuine, to be honest. Here, it's possible to read the jury notes. And why is the word possible in quote marks? It seems, why is the word possible in scare quotes? It's not possible, it's possible. I'm confused. Thank you, Tony P, for the gift memberships. Thank you, Sherry D, for becoming an uncivilian. We do appreciate it. Here it is, quote unquote, possible to read the jury notes in the context of the trial court's instructions as reflecting an impasse on one count but not others. The jury's reference to quote unquote charges is easily reconciled with post-trial affidavits affirming the only deadlock related to the lesser instructions. Yeah, the question, of course, is whether or not the judge made a mistake at the time. Right? You can't use what you know now to get you there, right? And since that's not how it works. The judge either made a mistake at the time or not. The fact that you now know the answer doesn't make it a mistake at the time because the judge obviously didn't know that. So, it can't be a mistake. All right, cool. Let's see. In this context, the file note was facially susceptible to alternative implications. The jury had reached an impasse on all charges, or the deadlock only applied to some of the charges. It was not an unambiguous note affirmatively declaring an all impasse on all charges as assumed by the Supreme Judicial Court. Well, I know, you can't see the text. I'm screening. I apologize. I didn't switch back. Yeah, I don't know whether or not the Supreme Judicial Court necessarily assumed that or just assumed that it just didn't matter either way. The jury's failure to expressly mention its agreement on count 1 and 3 is understandable in light of the court's instructions. It should continue deliberating until it reached a final verdict on each charge. Well, was that instruction an error? Was that instruction an error? If not, I'm not 100% sure what we're talking about. For those reasons, the Supreme Judicial Court was wrong to characterize the note underlying the defense motion as inconsistent with the jury notes. The jury simply never stated it was able to reach jury verdicts on any of the charges. The Supreme Judicial Court did not mention, let's analyze the reading of the notes set forth by the defense above. I don't believe that's true. I seem to recall the Supreme Judicial Court did mention the notes. I read the opinion recently. I'm pretty sure they mentioned the notes. Am I being gaslit by the defense right now? I think I'm being gaslit by the defense. I'm confused. The trial court took no steps to clarify the jury's notes. In the double jeopardy context where the Commonwealth alone bears the burden of establishing manifest necessity, this ambiguity must be read in defendant's favor. I mean, yeah. The Supreme Judicial Court therefore erred in construing the jury notes, as an unambiguous declaration of an impasse of all counts. In sum, a decision made so precipitously could not have been the product of any careful consideration of the value right of defendant to have her guilt or innocence determined in a single trial. This by itself precludes the Commonwealth from retrial on counts 1 and 3. I appreciate the defense's enthusiasm, and they do have just a sliver here. They do have a sliver. So I wouldn't go so far as to say frivolous, because frivolous is a 4-letter word to a lawyer. Right? Frivolous is a 4-letter word to a lawyer. You don't want to say something's frivolous. So I wouldn't go so far as to say frivolous, but I don't think it's going to happen. I don't see it. What constitutes an acquittal is not to be controlled by the form. That is broadly true. Rather, the court must determine the action actually represents resolution, correct or not, or some of all the offenses charged. And they're citing this Supreme Court case. With respect to the charges that they are charged to, sure. Labels, including those provided by state law, do not control the analysis. That is true broadly in law too, incidentally. Like, labels are not the thing. Labels are not the thing, right? We don't really care. We don't care what you call it. We care what it is. You know, we don't really do law by magic words. Not really. You know, it's not a name. They're just helpful labels to help us describe the thing. So sure, the label is not the thing. I appreciate that. That's very true. That is because whether an acquittal has occurred for the purpose of double jeopardy clause is a question of federal, not state law. With respect to the Fifth Amendment, you better bet your ass it is. Of course it is. 100%. No one denies that. 100%. Obviously. Duh. The Fifth Amendment is part of federal law. Obviously, it's a question. It's a federal question. No duh. And ultimately, it's the federal courts that determine what federal law is. States will obviously try to do their best. They're supposed to. But of course, they get it wrong sometimes. And so the federal courts obviously can overrule the state. Well, overrule isn't quite exactly the right word. They can say that their decisions are inconsistent with federal law and be like, try harder. So yeah, that's for 100% true. Here are the affidavits by Attorney Jackson and Yannetti reflect statements by 4 deliberating juries. The juries had reached a final unanimous conclusion that Miss Reed is not guilty as to counts 1, 3. Yeah, well, I mean, we obviously are presupposing that 12 jurors said you not guilty, right? We because it doesn't, right? We can, if we needed to know for sure, we could get the members of the jury in and we could ask them, and presumably we'd have to ask all 12 members of the jury. Right? Presumably, we'd have to ask all 12 members of the jury. And then what happens if, like, even one of them says no? Then what do we do? Right? It's like, no, that isn't true. Then what do we do? That'd be fun. But like, we don't even have to do this if their answers don't matter. If all 12 of them were to say, yeah, that's really what we thought, does the answer matter? So I was like, okay, yeah. I appreciate you guys spending some time with me, by the way, on a Saturday. That's nice of you. It's a little chilly here in Houston right now. It is 40 degrees. It's a little chilly and windy, and I'm not necessarily a happy camper. Let me read the super chats that have come in so far, because I probably missed some of them. Legally minded friends, Karen Cole became an uncivilian. Sherry D became an uncivilian. Tony P gifted 10 gift memberships. Christy B gifted 5 gift memberships. We read Crispy's chat for $4.99 earlier, but thank you again. Team Brittany, thank you very much for being here. Thank you for being a mod on Melanie's channel as well. We do appreciate it. We do love our cupcakes over there. You guys are great. Gifted 5 gift memberships. BL Blazy became an uncivilian. Ann Bell Feinstein's been a member for 39 months. And we read Pro Gamers membership chat earlier, and we do appreciate all that love. It is super duper appreciated. By the way, while I'm taking a moment to myself, because, I just like to say that I'm pleased to announce that I have lost 30 pounds off peak. So that is good news. I have been on Mounjaro recently, and I'm pleased to say, and I was also on semaglutide before that, but the semaglutide had more side effects, and I wasn't a happy camper. I'm much happier with the Mounjaro. In any event, I've lost 30 pounds. And so, yay. I probably need to lose at least another 140 pounds. But, it's a start. So, success. Good news for me. Let's see, where were we? Okay. There was nothing tentative about the jury statements. To the contrary, they were definitive in describing the result of their jury deliberations. We know what the notes are. We got it. Despite the significant publicity that accompanying the following defense motion relied on jury discretion declarations, none of the remaining jurors or ever communicated court, the court staff, the district attorney's office, defense counsel, or the media that disputed the accuracy of the 5 jury representations. Very cool. In rejecting Ms. Reed's claim of acquittal, the Supreme Judicial Court relied solely on the lack of formal verdict returned, received, and recorded in open court. This reasoning is rooted in formalism that's been consistently rejected by the Supreme Court in a string of precedents spanning more than 100 years. I mean, to some degree, yes, but no, not really, not here. I'm not feeling it. The Supreme Court has, for example, consistently refused to rule that jeopardy for an offense continues after an acquittal, whether the acquittal is expressed or implied by conviction of a lesser included offense. Yeah, I mean, fair enough. If the lesser included is acquittal, then obviously the greater can't be guilty. I mean, that's logically required, at least if you're trying them as separate crimes and separate days. Crispy gives $1.99, say, congrats, know the struggle on 30 pounds is a big win. Thank you. Thank you. I'll be happier when I'm under 300 pounds again. Hopefully sooner rather than later. That'd be nice. Yeah. And I need those super chats to pay for it because it's very expensive. It's $650 a month. So I'm not beyond asking, please help fund me so that I can continue this, because I'd really like to lose the weight, and it's the only thing so far that's worked for me. And I could really use your help and assistance in this time while I'm trying to treat this medical problem. So if you wouldn't mind throwing a couple bucks in the tin, it would be really nice, since I have to pay $650 a month from somewhere. I'd appreciate it. Under the Supreme Judicial reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. Unfortunately, I think it's the law. I think it is exactly the law. I know, because, again, like, the problem is, what if it's the other way, right? The rule has to be fair. The rule has to be fair, right? So he writes, under the Supreme Judicial Court reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient. That is, in fact, the law, because it's equally the law that affidavits executed by all 12 jurors attesting to a final unanimous decision to convict would not be sufficient. That's exactly why it can and should be the law. So in contradiction to his statement that it cannot be the law, it must not be the law. No, it really does need to be the law, because if 12 jurors wrote an affidavit saying totes convict yo, that's not sufficient either. And you better believe your ass that the defense would be screaming to the courts. I mean, can you imagine the I know you can. You can obviously imagine the counterfactual. Can you imagine if this was all reversed and it were the prosecution who was writing in a brief that if the prosecution was writing in a brief, under the Supreme Judicial Court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to convict would not be sufficient to determine a conviction. Surely that cannot be the law. Indeed, it must not be the law. Can you imagine what the defense would be writing in response to that? The defense would be going absolutely out of their mind, and rightfully so. And rightfully so. Thank you very much, 9 Lives, for the $9.99. And thank you, Maximum Bacon, for the $10. Those are both appreciated. Thank you. Yeah, so not only can it be the law, not only should it be the law, it is the law, and it should be the law. Because if the rule were the other way around, that sounds insane. That sounds like a really bad thing. That sounds really, really bad. You know? And in the context of this highly publicized class, it strains credulity to suggest that if unequivocal statements of 5 jurors quoted above in fact did not represent the unanimous view of all 12, the remaining juries would allow the inaccuracy to go uncorrected. I take a strong exception to that statement too. I take exceptionally strong statement to that too. That statement makes me a bit mad. I have to be honest. That statement makes me mad. It strains credulity that if the 5 people didn't represent all 12, we would have heard from other jurors. Like, bitch, no. The judge was quite clear, as they should be, that the jury is under no obligation to talk to anybody about their service. Maybe one of the 7 members doesn't agree and they really don't feel like going public right now because they feel like there'd be too much backlash. I mean, can you think of any rational reason? I mean, let alone because I want to, which, by the way, is a purely rational reason in this context because it's their right. So putting aside just because I want to, can you imagine any other reasons that if there was a juror who'd been like, no, that's not right. We weren't unanimous. That's not right. Can you imagine any other reasons that juror might not necessarily be super duper thrilled to make themselves known? Can you imagine any other reasons that juror might not necessarily want to shout, nope, that's not true. We weren't unanimous. That's lies. Can you imagine any other reasons that this juror might not come forward? I can imagine other reasons. I'm not sure it strains credulity. No, I am not incredulous. I can imagine some fairly reasonable reasons that all those things. Where our system says it must be fair, rules have to be fair. Where does it say it must be fair to the prosecution? It's not necessarily that it has to be fair to the prosecution. The rule has to be fair to both sides. The rule has to be fair. Otherwise, what's the reason of having unfair rules? Right? That doesn't make sense. Now, the Constitution does create some specific rules for the defense. So if those are unfair, then the Constitution does specifically contemplate some specific rules for the defense that are perhaps unfair. So maybe there are some examples of unfair rules, but the Constitution explicitly contemplates that. Otherwise, we need a fair rule. The game has to be fair. The game has to be fair to both sides. The rules have to be fair. So it has to give and take with equal measure. You know, it can't be based on, you know, the people or our side or what we like or who we're rooting for that day. You know, the rules of the game can't be dependent on who we're rooting for that day. The rules have to be even. I mean, the only alternative is that you're suggesting the rules should be unfair, which seems odd. I mean, even if they're unfair in favor of the defense, that does seem odd. It's like we should have unfair rules. Like, really? We should have unfair rules? I don't know about that. I mean, the Constitution does explicitly contemplate some rules, but, you know, beyond that, we should have unfair rules on top of that. Like, I don't know. I don't know about that one, but okay. Thank you, by the way, for Patty P for becoming an uncivilian. Thank you, Hobble for €5. Thank you. I appreciate it. Laws designed to never convict an innocent person? Well, that's an overstatement. That's not true.
New donation from Diana Kitty.
Thank you, Diana Kitty. That's very nice. Yeah, the law is not designed to never convict an innocent person. That's an overstatement. We only require reasonable doubt. The law kind of explicitly contemplates the possibility that innocent people might be convicted because reasonable doubt isn't all doubt. Innocent people have, that's definitely not true. That's an overstatement. Sherrod for $5 says super chat request. You'll get their weight loss goal. Thank you for your impromptu cupcake stream. Always happy to stream for cupcakes and non-cupcakes alike. We like cupcakes over here. Cupcakes are our friend. Hobby? Hoobie? I mean, who is it? Hoobie? Hobby? I don't know. Hoobie? I don't know how else to pronounce the name. I'm doing my best. It's not necessarily obvious. Don't make fun of me. I'm doing my best. The state has all the power and resources, but we're talking about the court rules. We're talking about court rules. We're talking about the rules to adjudicate. We're talking about the rules of the game. So your analogy also doesn't quite make sense, right? So I don't know what scenario this would be, but if the Yankees, well, I guess Brewster's Millions. If the New York Yankees were playing the Hackensack Bulls, right, in an exhibition game, the fact that the Hackensack Bulls are not on the same league as the New York Yankees does not mean we change the rules of baseball. The New York Yankees may in fact have way more resources and better players and all the rest of it, but it just means the Hackensack Bulls going to go down, yo. So yes, the state may have more resources, but it doesn't mean we change the rules of the game. So no. If that were the case, immunity wouldn't exist. Well, I don't know what you mean, but if you're referring to double jeopardy immunity, the Constitution explicitly creates it. So it's an exception to the principle. So that is an example of a rule that favors the defense. You're correct, but it doesn't necessarily mean other rules are changed. That doesn't make sense. Okay. The Supreme Court's decision in Bluford, which I thought was a pretty interesting case to be sure, is not contrary as it's factually distinguishable from the instant case. There, the foreperson had reported during deliberations that the jury was unanimously against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberation. So the jury said, not guilty as to some counts, but we're not sure as to other counts. So that court decided to send the jury back on everything, and then the jury couldn't figure out any of the charges. So the jury went from we're unanimous to we can't make up our mind. We're unanimous as to acquit, and then try harder though, and then they're like, we can't figure it out. In doing so, the court relied heavily upon the lack of finality. The jury's deliberations had not yet concluded because it went back into the jury room. So even though they're like, we're ready on count one, as to the capital murder, it's like, well, could you try harder on count two? And then they're like, we can't figure out count one either. So the Supreme Court of the United States said that's not a final resolution. There's no indication that was still the case that all 12 jurors believed the defendant was not guilty of the capital or first-degree murder. Here, by contrast, the jury statements reflect a final and indelible determination that persisted through the end of deliberations and following. I suppose, but we're still back to does the judge have to accept partial verdicts? Is that a thing they're required to do? And if the answer to that question is no, if the judge is allowed to say all or nothing, then there's no error. There's no abuse of discretion, right? So, okay, fine. Defense respectfully submits this court should hold that Miss Reed may not be forced to stand trial a second time for an offense a previous jury found her not guilty of, simply because a final unanimous agreement was not announced in open court, or any other way, to be honest, at the time of trial. They didn't, yeah. Any lack of formality does not supersede the fundamental constitutional protections. Yeah, we're willing to forego some formalities. It doesn't necessarily mean we're willing to forego all formalities. And then they cite a case from the Fifth Circuit, which apparently in that case affirmed affirmed correction of a verdict on one count after receiving a telephone call from two of the jurors stating that contrary to the verdict read in court, the jury had unanimously voted to acquit. I guess that judge failed to ask them whether or not that was their verdict or not. So that seems like the mistake, right? I mean, you don't know because we're only getting a piece of it. But if I would infer what happened is the judge read the verdict and then didn't ask the jury whether or not it was in fact their verdict. And so he didn't give the jury that chance. And so that was probably the legal error in that case, if I were to guess. Because that sounds logical. Then they cite another case from the Ninth Circuit affirming changing verdict on account where post-verdict interviews of several jurors determined the jury had intended to acquit. Okay, I mean, we'd have to read that Ninth Circuit case, I guess, to see how close it is on point. They're not giving me enough information. They're giving me one quote. So I'm not sure how on point that is. If you're a good chat and you want, we could potentially read the Ninth Circuit case if you're interested and see how close it is. But I have my doubts. So let me know in chat if you want me to discuss the Ninth Circuit case or if you care. If you guys want to, maybe. The issue is one of existential importance, not merely to Miss Reed, but to the very foundation of the constitutional safeguards that protect her. Okay. Alternatively, we're entitled to an inquiry to determine whether evidence supports the jurors' representations of having acquitted Miss Reed. Not unless there's a reason for it. The Supreme Judicial Court narrowly construed the right to a post-trial judicial inquiry to substantiate a constitutional violation as limited to claims the jury was exposed to extraneous information or demonstrated racial or ethnic bias. That's typically why we don't really like to pry into jury deliberations. Not really a thing we like to do. Under this logic, no defendant claiming jury acquitted her but failed to announce the verdict would be entitled to further inquiry, no matter how well clear and how well supported. I mean, true. That is a true fact. You're correct. Yeah. In other words, even if all 12 jurors submitted affidavits saying they unanimously and finally agreed to acquit, the failure to announce the verdict would take precedent. That is true. That is correct. You are not incorrect. Defense respectfully submits that violates the rights. I'm going to go with no. Yeah, I know. But again, like, if all 12 members had submitted an affidavit saying guilty, right, that wouldn't be enough either. So, I mean, because we're trying to determine what in fact the jury thought, right? This is the thing, right? We're trying to determine what in fact the jury thought, whether they thought guilty or innocent, right? So if the jury in fact thought guilty in their own head, but for some reason that wasn't reported to the court, okay, that would be the jury's determination in their own head. So if all 12 members submitted an affidavit saying, no, we really thought guilty in our own head, is that now a conviction? I mean, it's a final verdict by the jury. All 12 members confirm it, right? So is that a conviction? Because all 12 members are submitting affidavits? And if the answer to that question is no, it's not, then it's the same rule the other way around. Because if the jury in fact thought guilty, then guilty till proven innocent, or innocent till proven guilty is no longer a thing, right? Because innocent till proven guilty, well, if all 12 members thought jury, then she's no longer presumed innocent because she's guilty. So, like, there's not even prejudice, presumably, at that point, because, you know, the burden of the presumption of innocence would arguably be over. So it's like, if that's it, does this rule go both ways? And I don't think it does. Okay, Stauffer was convicted of drug distribution, Hawaii extortion, and travel charges, but acquitted on Nevada. Jurors later revealed they'd mixed up the extortion counts. That's super interesting, Samuel. Our continuing faith in the jury system continues to be questioned with every passing moment. So in the Ninth Circuit case, the jury's like, we made a mistake. We confused the extortion counts. We confused one count for the other. My faith in the jury system continues to be challenged with some of these cases. Yeah, okay. That's exciting. Why not ask the jury what their vote is? Not deliberations, just their verdict. Well, we've discussed that. We've discussed that, and it's like there might be reasons the defense might not be so thrilled with that, right? There might be reasons the defense might not want to do that. So, yeah. The court corrected the verdict, convicting him of Nevada extortion instead. That's interesting. I might read that case because that sounds like nightmare fuel. That sounds stupid. Oh Lord. That sounds like a shit show of a case. Help. In the analogous context of jury bias, the law is clear the defendant's Sixth Amendment right to an impartial jury also guarantees the opportunity to prove a claim of bias. Thus, a non-frivolous claim of jury taint, you said taint, triggers the trial court's unflagging duty to adequately prove the allegation. Well, if we were issued in the jury being tainted, then maybe, but that's not what we're talking about. Crucially, the court does not have discretion to refuse inquiry when confronted with juror misconduct. That's also not what we're talking about. The required inquiry may include taking of jury testimony because a categorical bar of such testimony would violate the principles of justice. Yeah, in those examples it would, sure, but that's not where we're at. Recently, in United States versus Zarnev, in the First Circuit remanded the matter for further proceedings in the Boston Marathon bombing case due to two jurors' postings on social media regarding the bombings and district court proceedings, which came to light after the juries had provisionally selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant, which fair enough. If there's bias by the jury, then that's something that you might want to look into, but that is not the situation at hand. No one is suggesting that at the moment. The comments were also inconsistent with jurors' assurances that they had not discussed the case online. Yeah, obviously they have discussed it online if there's a post. The First Circuit held the district court erred by failing to inquire about the issues with the jurors. Fair enough. Given that the right to an impartial jury is a constitutional bedrock, when there's a plausible claim a prospective juror lied in a manner that may receive bias, a court need to conduct an inquiry reasonably calculated to determine whether the jury lied and if so, why. Although the district court has broad discretion to determine the type of investigation into the bias, notwithstanding this broad discretion, a district court does not have discretion to refuse to conduct any inquiry. So, you might have an option of what to do here. It might not necessarily require putting the jurors under oath. There might be another way to go about this, but you might need to do something to look into it. Fair enough. Fair enough as far as it goes. That's fine. But no one is accusing this jury of bias, so the case, as we say, is an opposite. Crucially, for present purposes, the First Circuit ordered the district court to voir dire the jurors 9 years after the trial. Okay, fair enough. In doing so, the court acknowledged no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect most jurors, having taken time in their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict they believe is just, would prefer not to have that verdict disturbed, especially as a result of their own actions. We have no doubt that the ability of the district court to do what judges do, form a considered opinion about the sufficiency of the explanations once the explanations are given. Cool. Post-verdict inquiry similarly regard to investigate claims of external influence. It sure is, but no one is alleging that, so it's an opposite. In Remare, after a jury returned its verdict, the petitioner learned for the first time that during a trial, a person unnamed had communicated with a certain juror, who afterwards became foreman, and remarked to him he could profit by bringing a verdict favorable to the petitioner. The court, without defense's knowledge, then enlisted the FBI to investigate. The Supreme Court held defense was entitled to a post-verdict inquiry regarding the FBI's unauthorized contact with jurors. Okay. Defense respectfully submits that no less than the conviction rendered by a biased jury or impermissibly tainted by external influence, requiring a defendant stand trial for murder after unanimous verdict found her not guilty would violate the plaintiff's principles of justice. We are very loath to look into jury deliberations. It's something we do not like to do, something we try to avoid a lot. So, yeah. Isn't the presumption of innocence over as soon as closing arguments are finished and the judge charges the jury? No, absolutely not. No. It's innocent until proven guilty. So the presumption of innocence needs to remain throughout the trial, including jury deliberations. Yeah, if the presumption of innocence is not being maintained by the jury as they're deliberating, something has gone wrong. So, yeah. All right, let's see. Indeed, the Supreme Judicial Court did not suggest otherwise. Instead, it erected an artificial dividing line between Fifth Amendment protection against double jeopardy and Sixth Amendment right to an impartial jury. Defense respectfully submits this result is not supported by precedents or logic. Unfortunately, it's the defense position that isn't really supported by precedent. While the foregoing authorities arise in different contexts, they stand for the proposition that the defendant who comes forward with credible evidence of serious constitutional violations post-trial must be entitled to an opportunity to prove the claims. There's no apparent reason to artificially limit the availability of the inquiry, such as the Supreme Judicial Court did, to racial bias and extraneous influence. There's many, many reasons to be cautious of that. The defense acknowledges that there's little precedent involving situations factually similar to that. This case is unique. So this case is sui generis. Yeah. If that's your position, you're going to have a really tough time with the federal court, especially on a habeas petition, right? Because habeas, no, not really. Not unless there's clearly established federal law for a habeas. So if you're like, oh, this is unique, this is special, on a habeas review, not really. No, that's a real problem. But the unique strength of evidence underlying the defense motion to dismiss supports rather than undermines the claim. Contrary to the Supreme Judicial Court characteristic, defense requests did not seek to probe the content of deliberations. To the contrary, requested inquiry is directed solely to the result, namely a unanimous decision. I mean, I suppose as far as it goes, yes, but still, like, does it matter? Right? That's the problem. So you can't have your inquiry unless the result would matter.
Donation from Diana Kitty.
Thank you, Diana Kitty, for the nice donation. That's very, very thoughtful. So you can't have your donation unless it matters. Incidentally, by the way, the donations through Ko-fi are somewhat preferred because I get a much bigger cut of them. YouTube takes 70%. YouTube is, or apologize, they don't take 70%. That'd be really horrible. YouTube takes 30%. I keep 70%. Ko-fi takes like 5%. So I get a much bigger cut of the money. So they are preferable, all things being equal. And we do appreciate your support in any event. St. Elmo's Fire says, why did the Massachusetts Supreme Court say it was all okay? Well, as to that question, I would invite you to watch my prior video where I break down the state level Supreme Court decision and tell you why they said it. So if you want to know why the Massachusetts said it was okay, there's a video for that on my channel. Perhaps you'll find it interesting. In any event, evidentiary rules cannot extinguish a criminal defendant's fundamental rights. The inquiry requested by defense could be accomplished by a single yes or no. I'm not necessarily sure that's true, by the way. That's true in the best case. I'm not necessarily sure that's true here, even as a matter of fact. Because I'm not sure if you know, just imagine, like, if each juror was asked, were you unanimous? Were you all unanimous as to these counts? And 11 members said yes and 1 member said no. Do you really think the defense would be satisfied? Well, we have no further questions. Do you really think the defense would be satisfied with one question? They're presuming the answer to the question. They're presuming all 12 members will say yes. What if one of them says no? What then, defense? What then? What are you going to do? Something tells me you will not be happy. The inquiry rested by defense could be accomplished by a single yes or no. Sure, it could. Of course, the results of the jury deliberations are not secrets. The results, I suppose, are not. They are, in fact, routinely announced in open court. True. Here, defense learned post-trial jury reached a verdict that was not announced. It was entitled to an opportunity to substantiate that fact in order to ensure Miss Reed is not unconstitutionally forced to stand trial for a criminal offense of which she already been acquitted. Such inquiry in no way intrudes on the deliberative process of the jury. Such inquiry instead honors the jury service to which the trial judge described as extraordinary, rather than disregarding the efforts of 5 jurors to disclose there was not an impasse as to all 3 counts. The trial court recognized defense repeated requests to order the post-trial voir dire of the jury, where the court could make inquiries, because they ignored it because they determined it didn't matter. That's why. You know that. I know that. We don't need to ask if the answer doesn't matter. Why ask the question if the answer doesn't matter? Which would have occurred if the jury was polled count by count, with the Massachusetts rule permits, if not prescribes, and again, as to what the Massachusetts rule prescribes or otherwise requires, that's a question of state law, so it doesn't require it, because the Supreme Judicial Court didn't say that, so it doesn't require it, so no. Just no. That could be structured by this court or the experienced trial court to steer clear of overstepping the boundaries set forth by Massachusetts rules that could ask about the results of a jury deliberation without asking how the jury internally and reached that result. The First Circuit trusted post-trial inquiries to skill and experience of trial courts in matters ranging from extraneous influence to intrusions of racial or ethnic bias. Defense submits the values at the core of the double jeopardy clause, the primacy of a jury's decision-making as protection for accused. We're going back to that rhetoric. We're going back to high-ended rhetoric again. America is awesome. America is awesome, but not necessarily getting you where you want to be. America is totes great, but still, Essential to the values of our system, as is the right to be tried before an impartial and unbiased jury. Defense has met their burden of production. No. Far less showing statements by one juror have repeatedly led to holdings that jury inquiries are mandated. Sure, when those statements are of the nature of the jury was racist, the jury was sexist, the jury was bribed, the jury was threatened. The jury had extraneous communications from people. So sure, if there was one juror who was saying any of those things, you bet. But not so much in this circumstance, no. As in Terezanov, the law trusts the court to determine whether the answers to voir dire have been affected by media exposure. This has nothing to do with voir dire, at least the initial voir dire. There cannot be one set of rules for trial with publicity and another with trials without it. That much is true. That much I agree to. There cannot be a different rule for trials with publicity and without. That much I agree to. We cannot do a because Karen Reed. That's never a good thing. When courts try to do that, it goes to hell. Right? Because we work on a precedential system. So when courts try to do but this one time, though, holy shit. Holy shit. Yeah, when courts try to do but just this one time, though, you know, it's never just this one time. It's never just the tip. They're lying to you. They're lying to you. Defense respectfully submits that confidence in this court is eroded by creation of such impenetrable wall preventing jurors from informing the judge where they vote as the final matter to acquit. At the time of the public confidence in the jury is pivotal, not allowing jurors to be heard on matters of such significance, and allowing the trial court to decide without taking action to assert the matter of truth if there was a final unanimous verdict is inconsistent with the elevated role. For all these reasons, we'd really like the federal court to step in, and no. So yeah, no. I think the odds-on favorite still is the federal court is not going to hear this case. I think the federal court is going to invoke abstention doctrine and abstain from hearing this case. I think that's the odds-on favorite. And if they do decide to hear the case, it will be probably to swiftly say no and go away. So that is my prediction. And yeah, no. It was harmless. It was harmless error at best. Because the judge didn't commit it. The only real error really that could be said is the trial judge not asking the counsel what they wanted to do. Right? That's really the only real error, is not asking counsel. At the end of that third note. But again, like, the defense knew what was happening. They had to know what was happening. They could have stood up during the Jeopardy music portion and objected. They could have even asked, afterwards when the jury was sitting in the back room, wait, we have further thoughts or something. Like, the defense had opportunity, right, to stand up and express a thought, and they weren't. For them to say they were surprised, no. No. So I think it's harmless error at best, but I appreciate their enthusiasm. And I will be very interested to see if in the new exciting jury instructions they ask for partial verdicts. You like the scruffy look? Well, it's not totally scruffy. I do trim my beard, so but I try to make it look nice. I keep it trimmed. Hopefully, it's not too scruffy. People say they like the beard. You can't predict juries. That much is true for sure. All right, let's skim this Ninth Circuit case because I'm mildly interested on this Ninth Circuit disaster, if you will. They have a date of March 5th at federal court. Okay. Yeah, for an initial appearance, that sounds plausible. I'm trimming it to, I think, 9mm is the guard I'm using right now. So I'm trimming it to 9mm. Let's see. Where is this Ninth Circuit case? Let me see if I can find where it is in the brief, so I can pull the case because it sounds interesting. Where is it? Okay, no here, not here. Wish I covered Koberger. I don't want to cover the preliminaries of Koberger. It's a little in the weeds for my taste, but I'll definitely be covering Koberger later on. I'll tell you what. I can't find the case. Is this the one here? This Ninth Circuit case? United States versus Barragan Sapita? Which one is it? Into the validity of verdict? Is that the right case? Live stream the Tuesday night election loss of Tiffany Heard. That'd be fun. Koberger screwed? I don't know if Koberger screwed or not. The evidence so far that I've seen against him and that's been publicly available is not the most convincing evidence I've ever seen in my life. It looks a little thin for my taste, especially for a quadruple capital murder case. It looks a little thin to my mind. So I don't think so. There might be more evidence beyond what's publicly available, of course. That isn't to say that there isn't more, but I'm not convinced as of yet by any stretch. Okay, that's not the right case. Where is this case I need? I hate flailing around on stream when I can't find something, because now it's just a bunch of dead air, and no one likes dead air. Okay, thank you, Samuel. Thank you, Samuel. All right, let's pull up this other case. Okay, this looks right. This looks right. All right, what is going on in this case? All right. All right, cool. All right, United States Court of Appeal, Ninth Circuit, U.S. versus Stauffer, Court of Appeals. Stauffer appeals his conviction for conspiracy to distribute drugs. We affirm. Okay, let's see. Blah, blah, blah. Blah, blah, blah. Blah, blah, blah. All right. The verdict form reflected convictions on drug distribution conspiracy, Hawaii extortion and travel counts, and an acquittal of the Nevada extortion count. Post-verdict interviews of several jurors initiated by Stauffer's counsel determined the jury had made a clerical error. The jury apparently became confused concerning the numbering of the counts on their copy of the superseding indictment. Lol. They had intended to acquit on the Hawaii extortion account and convict on the Nevada extortion account. The trial court solicited affidavits from the jurors. All the jurors attested to the clerical error. Wow. Wow. At a final post-trial hearing on November 9th in 1989, the district court switched the verdicts on the two extortion counts to correct the jury's mistake and denied the post-trial motions concerning sufficiency of the evidence on the drug distribution and travel counts. Judgment was entered accordingly, and Stauffer received a sentence of 5 years. That's just funny. So the defense lawyer did an interview of the jurors, and the jurors are like, "Oh, we meant to swap these counts. We just meant to swap them." And they went to the court and like, "Oh, they meant to swap them." The court's like, "Okay, I guess I'll swap them." And now the defense is objecting to the swap that they sort of started. That's sort of funny. That's funny. Oh my God. All right, jury's gonna jury, man. Jury's gonna jury. On appeal, Stauffer argues the government present insufficient evidence to support the conviction for distribution and for interstate. He also argues that the government failed to prove an essential element of the crime, and judgment on count 6 violates his rights against being placed in double jeopardy. So we don't care about sufficiency of the argument, sufficiency of the evidence. So we're going to skip all that. We're going to skip all the sufficiency of the evidence and blah, 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 and get to the double jeopardy thing, because that's what we're here for. Whether the district court's correction of the verdict form violates double jeopardy. Now, please take note, by the way, that they're correcting it from not guilty to guilty, incidentally, by the way. So this is a decision that changes a not guilty into a guilty. So, that's notable. It's sort of, we're trying to come up with rules. Also, of course, by the way, it's worthy of mentioning the Ninth Circuit. Massachusetts is not in the Ninth Circuit, so this is persuasive authority at best. The First Circuit could obviously disagree or distinguish or whatever, so it's not binding, but it's interesting, so I'll read it anyway. In United States versus Sanders, this court stated that jeopardy attaches when the jury is impaneled. It sure does. At that point, the defendant has a valuable right to have the trial completed by a particular tribunal. Double jeopardy protections, however, has its limits. And see, this is funny because they cite a First Circuit case, right? Because they cite each other all the time. So here's a Ninth Circuit case citing the First Circuit. So maybe the First Circuit will cite the Ninth Circuit. Who can say? So in a First Circuit case, the courts say the defendant's interest is not the only one at stake. We also must consider societal interest in punishing one whose guilt is clear after obtaining a fair trial. Stauffer argues that though the district court acted properly in switching the guilty verdict to acquittal on the Hawaii count to reflect the jury's true intent, it was a violation to switch the other one. So we want a one-way switch. We want a one-way switch. And the judge is like, how about I just switch it both ways? And he's like, that's not fair. No swappity-do both ways around, I guess. Lol. Stauffer argues the first jeopardy concluded when the jury left the courtroom, and district court should not be allowed to reinstate the jury verdict over a jury acquittal, no matter how egregious the error. Allowing the district court to take such action, according to Stauffer, would do violence to the historical notion of jeopardy in a jury trial by leaving open as a post-verdict pre-judgment limbo. So maybe, this case actually stands for the proposition that maybe in the counterfactual, the prosecution actually could come forward with those 12 affidavits of guilt and get their conviction. That's sort of what this says, right? That's sort of what this rule sort of seems to imply. So as to but what about if this was the other way around? What if it was the prosecution? Maybe the right answer is, but it does go both ways. Maybe we are comfortable with that. Maybe we're just happy if the prosecution can present 12 affidavits that say, nope, we thought guilty. We just checked the wrong box because we're a bunch of morons. Maybe that's okay. At least in the Ninth Circuit, it's okay, I guess. Allowing the district court to take this action, according to Stauffer, do violence to the history of notion of jeopardy and jury trial by leaving it open to post-verdict pre-judgment limbo. Stauffer argues that remaining to the true nature and purpose of the double jeopardy clause requires that protection arise after the defendant has experienced a trial, the verdict be read and jury discharged. All right, so let's learn about verdict modifications. Exciting. There is case law supporting correction of judgments to reflect the intent of jurors. In a Fifth Circuit case, the jury returned a verdict convicting the defendant of all 10 counts. After the jury was dismissed, 2 verdicts phoned the judge to tell him the jury actually voted to acquit on the 10th count. After confirming the jury's disclosure, the district judge changed the verdict to reflect acquittal on the 10th count. The Fifth Circuit affirmed, concluding the district court's action was permissible exception to the general prohibition into inquiry of the validity of the verdicts. The prior Ninth Circuit case that comes most close to this is United States versus Anzalone. In Anzalone, the jury returned a verdict of acquittal on several counts of the indictment. However, when the jury was polled, one juror could not state the verdict was her own. The judge sent the jury back for further deliberations, but a unanimous verdict could not be reached. A mistrial was declared, and the defendant was later retried on the same charges. This court declared the defendant's subsequent conviction on one of the counts that was previously announced not guilty did not violate double jeopardy clause. The Anzalone court cited a Ninth Circuit case that addressed the question of whether a jury verdict becomes valid. In that case, the court indicated the jury's task is complete when deliberations are finished, the result is announced in open court, and no dissent is registered. In the instant case, the jury was discharged before the judge corrected the verdicts. While this court might seem to be going further than Anzalone and Nelson, if it affirms the district court switch, such a ruling appears appropriate. Rule 36 of Federal Rules of Procedure provides clerical mistakes in judgments, orders, or other parts of the records and errors in the record arising from oversight or omission may be corrected by the court at any time and after such notice as if the court ordered. The district court did not alter the jury's verdict. It simply corrected the verdict form to reflect the true intent. Okay, so this case is actually kind of helpful to Karen Reed, I think. This case is kind of helpful to Karen Reed. This is, actually pretty interesting. And in this case, it's a correction to guilt, which makes it even more interesting for my money. So I like this case. I still don't necessarily think I would use this case as a First Circuit judge, but I'd actually have to think about it for a half second. So, as a First Circuit judge, what would I do in this situation? It's like I'd actually have to think about it for half a second, because it's kind of an interesting case. But also, this is permissible language. It may be corrected by the court, right? This is all permissible. So it's something the court can do, but it's something they have to do. So from a habeas posture, because in this case, it was federal charges, right? It was federal charges in federal court. So they're in direct review of themselves. This case is a little bit different because it's habeas review. And the federal courts really can only intervene if there's a clear error of federal law, right? So in this case, in the Ninth Circuit, they're saying what the federal judge did in a federal case relating to federal rules, right? As opposed to what a state court did. And that's a different posture. Separate sovereigns, man. Separate sovereigns is a big deal. So this case is on point to a point, but in terms of habeas review, the habeas review is much more narrow. So I still think I'd say no, but I do appreciate that it's a little bit more material. Clearly, decreasing the impact of judgment is less problematic to the defendant than expanding its impact. Still, the court is convinced no possible unfairness can be found from this. Fair enough. Fair enough. Okay, fair enough. Cool. Thank you, Faz Ra 8841 for becoming an uncivilian. So, interesting. Yeah. Yeah, but this was a federal case through and through. And this is a habeas posture. So, and it's also permissible language, so it's not quite on point. The defense doesn't really have anything on point. So I think the odds-on favorite are still for the district court not hearing the case on abstention doctrine, and if they do hear it, in saying no, because no. So pretty interesting stuff. Pretty interesting stuff. So I think it's unlikely they're going to intervene, but we'll see. We'll see. Will Karen Reed wind up at the U.S. Supreme Court? Will we have oral arguments? And if so, by the way, I'd like to offer my services to either side, by the way, because I can do this either way. I'm happy. I'm more than happy to do this either way. If either side winds up at the Supreme Court and they need a lawyer, I'm more than happy to advocate for you. I'll advocate for the Commonwealth. I'll advocate for Karen Reed. It's all good, man. I'm available. I'm a mercenary for hire. Call me. I'll do a good job. All right, so is there anything else for us to discuss today? I don't think so. I think that is the end of discussion for today. Of course, on Tuesday, we're going to have this hearing relating to this bombshell, which I'm not even quite 100% sure what the bombshell is exactly. But we're going to have this hearing that relates to defense attorneys' misconduct relating to ARCA. They did something that the judge thinks is a bad. What exactly they think is a bad is, I don't know. What are my thoughts on the dismissal motion? In the Karen Reed case? No. There's a prima facie case. It shouldn't be dismissed on a prima facie. As to whether it should be dismissed on the evidence at the evidence of the state's case in the first trial, I would have strongly considered it. I would much more strongly considered it than this district judge did, than this trial judge did. So at the end of the state's case, when they moved for a judgment of acquittal, I would have pondered it longer than 3 seconds. The state's case was in such complete shambles and such a complete joke, I would have strongly considered a judgment of acquittal on that burden. But yeah. Beard off if I go to the Supreme Court. I'm more than happy to take off the beard for the Supreme Court. I'll dye my hair funny colors if it will help. I'll dye my hair purple if Massachusetts likes that kind of thing. I don't really think it's a good look for the Supreme Court, but I'm happy to help. I'm not sure the Supreme Court would appreciate purple hair, but it could be a first. Go Tigers. Purple and orange are available colors. Well, I'd convict someone if I know they're innocent. No, that's a different question. Just Me Gaming. You're asking me a different question. All right. Because I have to remember my role as a judge, right? I have to put on my judge hat now, right? You're asking me to enter a judgment of acquittal. And that's kind of a big deal. And I know it's a big deal. And, I'm thinking the fact I'm even contemplating it is sort of a no. But you obviously as a judge, you have to apply the law as best you can, and of course, Aunt Bev should apply the law correctly, and so we try to assess each thing unto itself as best we can. as try to assess whether or not the law is being applied correctly or not, or whether or not things are being applied correctly or not. So, as a judge, it's not my role to enter a verdict of guilty. That's for a jury to do. But whether or not I, as a judge, would either enter a directed verdict or a judgment notwithstanding the verdict, do I go that far, is kind of a big deal. And so, I think about it. To be sure. Yeah. Any other questions I can answer for now? Because the prosecutor can appeal it. Well, they can't appeal a directed verdict, but they can appeal a judgment notwithstanding the verdict, I think. But it's still like you want to get it right because it's such a big deal. As a judge, I'm not necessarily worried about being overruled. I just want to do the best I can and apply the law as best as I can, and I know it's a big deal. And I also know as a judge that I can't necessarily give the verdict that I personally would want. So what I want is not necessarily, a judge who always gives the decision they want is probably a bad judge, as Justice Scalia famously said, right? A judge who always rules the way that they personally want is probably a bad judge. Yeah. So I'm on more than one occasion on this channel, although not extremely often, but on more than one occasion, I've had to be like, yeah, I'm ruling this way, and also I hate myself. I'd be like, this is what I think. I'm ruling this way. Also, I hate myself because it sucks. But you gotta stay within your role. Anything else is corruption, of course. Anything else is corruption. So you gotta stay within the rules. What do I think about the Commonwealth using off-the-record notes to support the motion for sanctions? I don't know what off the record. What is that? That's my first thought. Off the record. There's such a thing called off the record. Since when? Yeah, that's my first thought. Off the record. What? Who told who that there was such a thing as off the record? This isn't a reporter. This is off the record in the context of a court proceeding. Off the record. What is off the record? Is that a thing? That's my first thought. I know you need the cash, but don't benefit yourself financially by punishing an innocent person. What the hell? Just Me Gaming? What the fuck are you talking about? This has nothing to do with money. It's trying to get the law right. You're not being nice to me. You're not being nice. You think I'm contemplating not entering the decision because I want to get paid? What the hell? That's mean. What are my thoughts on Judge Ho and Mary Adams' case appointing Paul Clement to argue against the position of dismissal? Paul Clement is awesome. Paul Clement is like one of the best lawyers in the country. So Paul Clement is awesome. I think if you can get the best, man, get the best. Yeah. Yeah. All right, I guess I'm going to go ahead and end the stream for now because I don't really have anything more to say right now, but I've really enjoyed our time together, and I really appreciate so many of you being here. It was very nice of you. Thank you for spending time with me. It made me happy. I appreciate you. So we'll be here on Tuesday. So make sure to tune in on Tuesday for that hearing as we try to figure out what Aunt Bev is mad about and try to figure out whether or not she should be mad. And whether or not there is a problem here that requires some sort of redress. It's like maybe there's something here. Not quite exactly sure what it is, but she seems to feel like she's been duped or fooled or lied to or something. So if there's a thing here, then let's figure out what it is. Let's figure out whether or not Bev is just in being irritated. Let's try to figure out whether or not she is just in whatever she's going to do relating to that irritation. Let's figure out whether or not she's right. That might be fun. So we're going to be here on Tuesday trying to figure out what the hell is going on and trying to figure out whether or not she's right to be mad and whether or not what she does about it makes sense and all the rest of it. It'll be good times. I've been Uncivil Law. Until later, my friends, I hope you have the greatest day.